Now in session.
Good afternoon, gentlemen, and welcome to the Court of Appeals. Want to take just a few moments before we get started and make sure everybody understands the procedure that we'll be utilizing. First of all, I want to tell you how much we appreciate you agreeing to participate in these video oral arguments. It is an unusual time that we find ourselves in, and this is obviously the best way that we think we can continue to hear cases and keep everyone as safe as possible. So we appreciate both of you participating. Before we get started, I want to introduce the panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And Mr. Boykins, you're representing yourself. Is that correct, sir?
Yes, sir, I am.
Okay. All right. Let me just basically tell you our procedure, and then I'll attempt to answer any questions you may have. And when we start the procedure here in a moment, you'll have 15 minutes to make your oral argument. You may reserve up to 5 minutes of that 15 minutes to use as rebuttal time to respond to the other side's argument. You don't have to reserve it. You can reserve it. It's totally up to you. But when you start your argument after you've introduced yourself, please let me know how much, if any, of that time you'd like to reserve for rebuttal time. Okay?
Sure.
All right. What we'll do, Mr. Boykins, is after we hear your argument, we'll hear opposing counsel's argument. We will take the case under consideration, and we will write a written opinion and file it in this case. So we're not going to make a decision today. It'll be a month or so down the road before we send out a written opinion in this case. Okay?
Sure.
All right. Do you have any questions about anything before we get started, sir?
No, sir, I do not.
Okay, then. Ms. Tebner, if you'll call the case.
Christina Knapp versus Jason Boykins.
All right. Mr. Boykin, you may proceed. If you would, introduce yourself and then just let me know if you're reserving any rebuttal time.
Yes, how you doing today, Your Honor? My name is Jason Boykins, and yes, I am going to use 5 minutes of my time for rebuttal time.
All right, sir. You may proceed.
Okay. Your Honor, today I come forward to the Court of Tennessee of Appeals asking the court to dismiss this order of protection filed by the plaintiff as a relief under 42 U.S.C. 1983, which provides a remedy for deprivation of constitutional rights due to the fact that my First Amendment rights being violated by the court and also being violated by the attorney in this situation. And today, and also, Your Honor, I feel as if, Your Honor, the attorneys, Mr. Yoakum, his political ties with the city of Memphis is what he used to persuade the courts to help this company violate my constitutional rights by placing this order of protection against me violating my amendment rights. As a temporary, I feel as if the plaintiff should have never been granted the temporary protection order in the first place. Ex parte order of protection is a temporary emergency order issued when the courts find that there is good cause to believe there is an immediate and present danger and that the petitioner will be victimized by respondent. And hearsay from an employee who had no contact with me after me being terminated, and a fox emoji with stars around his head that represents lacking of orientation that is used on a daily basis when text messaging or on social media is not a good cause to believe that there is an immediate and present danger to the petitioner. Also, Your Honor, on page 7, paragraph 15 of the appeal brief presented by Mr. Yoakum, the petitioner states that Friday, September the 20th, 2019, appealee was out of town, and on Friday and Saturday, September the 20th and 21st, the employees of the Pig on Bill where I once worked reported to the appellee that I continue to stand in front of the establishment and protest, which shows also that my actions weren't directed towards the appellee because my actions were if my actions were directed towards her, then I would have ceased my protesting while she was out of town and not continue to protest. Also, in my arrest affidavit, I presented inside of my appellate brief as Exhibit G, proves that I was not doing anything wrong and that I was exercising my constitutionally protected right by protesting, because it says that she called the police from another restaurant across the street and said that I was outside standing with a sign protesting. And that's all that I ever did, Your Honor, after my termination was protest. And I even tried to present my location and all that to the judge, Commissioner Smith, and she would not accept any of my evidence at all. And also the testimony from Jamar Taylor, which Attorney Yoakum says is valid, is invalid, because I have my location to prove that I wasn't on Beale Street. The time when he gave the police statement was at 1 p.m. My location shows and proves that I wasn't on Beale Street or around there until after 5:30 p.m. So how could he say in the police report that he just talked to me and I said that I was going to cause harm to the owner and to the petitioner? And also, Your Honor, Tennessee Code states that it has five elements must be presented to constitute a terroristic threat. A willful threat to commit a dangerous crime causing serious bodily injuries or death is made. The threat is specifically intended to be interpreted as a threat. It is not necessarily for a defendant to intend to follow through or even have the opportunity and means to do so. Threats must be unequivocal, unconditional, and specific, convoying gravity of purpose and immediate prospect of execution. Threats must cause fear in the victim. The victim fear has to be reasonable. And I feel like, Your Honor, and I didn't show any threats and I never threatened her at all. And even in the temporary, the ex parte order of protection, she states that I was outside of the business up to 10 hours a day. I have my location printed out to prove that I was never outside of her business for 10 hours a day. And again, Judge Smith did not let me show any of my evidence. I'm not a bad person. I never threatened anyone. All this is a defense for them to try to battle my charges that I filed against them with the EEOC. And I'm done with the argument, Your Honor. And
okay.
I'll use the
Okay. All right, sir. We will now, we appreciate your argument. We'll now hear from the appellee, and then we'll hear you in rebuttal. Okay. All right. Mr. Yoakum.
Good afternoon, Your Honors. Thank you, Brian Yoakum of the Shelby County Bar. I'm here representing the appellee, Christina Knapp. I am getting a little bit of feedback here. If Mr. Boykins can go on mute, that might be helpful for everyone. Appreciate the opportunity to present this case here to Your Honors. Stepping back a little bit here, this is a case of a manager of business on Beale Street. Her name is Christina Knapp. She unfortunately had to terminate one of her employees. That employee was Jason Boykins. Upon receiving his notice of separation on September 4th, 2019, Mr. Boykins immediately responded with threats and behavior that caused manager Christina Knapp to fear for her personal safety. The threats that were being made on the date of the termination were significant. Mr. but had they stopped on the date of termination, we probably wouldn't be here today. The issue is that they continued and they got bigger over time and continued to escalate. The threatening behavior continued for several weeks until we were able to get it under control with this order of protection. I would like to point out, make no mistake about it, your petitioner here, Christina Knapp, is a very strong woman. She is a multi-unit operations manager operating several bars and restaurants on Beale Street and in the downtown Memphis area. She served in that capacity for, I believe, about 15 years. So in that role, she's had to fire many, many employees operating all of these restaurants. She is also regularly on Beale Street till 4 a.m. by herself with large amounts of cash. In her old time working on Beale Street under those environments, she's never once called the police. She's never once filed a police report. She's never once asked for an order of protection. She is not a wilting flower. She's not one to be easily intimidated. And frankly, the actions of Mr. Boykins beginning on September 4th scared the daylights out of her. And she took actions in a linear progression that we think were appropriate. First, immediately on September 4th, upon Mr. Boykins receiving his notice of separation and Ms. Knapp saw his threatening behavior, she immediately called the police, filed a police report. Again, the first time she's ever had to do that. Later on September 4th, she received a report from an employee, Jamar Taylor, and Jamar Taylor made a written report as to what Mr. Boykins had told him that day. And Mr. Boykins told Mr. Jamar Taylor that Ms. Knapp and the owner of the Pig on Beale, Jim Lesapio, didn't know who they were dealing with, and that he was going to blow them up. He said he was going to blow this motherfucker up, talking about the building. That statement of Jamar Taylor is contained in the record, such that there is a record. The issues with respect to Mr. Boykins' shortcomings on the record are in our brief, but the written statement is there. Mr. Taylor was subpoenaed to the hearing in front of Judge Smith. Mr. Taylor testified at the hearing in front of Judge Smith as to what he heard Mr. Boykins say on September 4th about shooting Ms. Knapp and blowing the restaurant up. On September 4th, 5th, and 6th, Mr. Boykins didn't just rest and move on with his EEOC claim. He began to stand in front of the Pig on Beale and spew all sorts of vile and crass and inappropriate comments, such as Ms. Knapp and the restaurant owners were racist. I believe at one point he called one of the other employees a faggot. This was all out in front of the restaurant on Beale Street. He was not only doing it on Beale Street, he was broadcasting it on what's known as Facebook Live. I wasn't aware of what Facebook Live was. I've had to learn about it. Facebook Live is a streaming service where you could broadcast to anybody who's got access on Facebook. Or he would stream it on Facebook. He would leave it posted on Facebook for anybody to see. That went on September 4th, 5th, 6th. So on September 6th, the company, River City Management and Pig on Beale, retained me to hand deliver to Mr. Boykins a cease and desist letter, asking that he stop with such defamatory comments and action and threatening of its employees. That cease and desist letter only served to further exacerbate the situation. Mr. Boykins received the cease and desist letter on September 6th and immediately sent a text message, which is in the record, such as it is, to Ms. Knapp, not to the owner, not to me, as instructed in the cease and desist letter, but to Ms. Knapp, saying in short that, I apologize, I don't know how else to say this, but that Ms. Knapp could suck his you-know-what, and that he was going to take the cease and desist letter I had delivered to him and take it home and wipe his ass with it. So again, complete disrespect for proper decorum. The activity continued over the next few days, over the weekend. On September 11th, Ms. Knapp didn't know what for her safety, so she went to the Memphis Police Department and requested an authorization of agency to have Mr. Boykins removed from the premises if he were there. That authorization of agency was issued and served by the Memphis Police Department on Mr. Boykins. Undeterred by the cease and desist letter or the letter from the Memphis Police Department, the authorization of agency, he continued to do what he seems to continue to call protesting in front of Ms. Knapp's place of employment. And Ms. Knapp went and obtained an ex parte order of protection. I wasn't representing her yet at that point, but she obtained it. She wasn't able to get service on Mr. Boykins until September 20th. It took a while for the process servers to track him down, but they finally served him on the 20th. Ms. Knapp was out of town visiting relatives on September 21st and 22nd. And when she returned to work on Sunday, the 22nd of September, Mr. Boykins was in front of her place of business again, continuing to do what he had been doing ever since September 4th, and he was arrested for violating the order of protection. Since that time, this will be the fourth time that Mr. Boykins has made the arguments that you just heard. He's made those arguments in front of two judicial commissioners and then recently in front of Circuit Judge Valerie Smith. All three of those judicial officers have heard Mr. Boykins' arguments, whether or not it was just his argument and previously he was represented by counsel. He was represented by counsel before the Judicial Commission. He had an attorney at both of those, or before the judicial commissioners. He had an attorney with him for both of those. Those judicial commissioners, Poole and Reed, heard his arguments and told him that his understanding of his rights were incorrect and that his actions certainly qualified for an order of protection, and it was certainly reasonable that Ms. Knapp would be in fear based on what his continued action. So the order of protection was put in place. It had clear provisions for him to stay away from Ms. Knapp and her areas of her business. It couldn't have been any more clear. Judicial Commissioner Poole even instructed him not to go on Beale Street, just to make this real easy. Don't go on Beale Street and don't go by the Peabody Place parking garage where Mr. Boykins knows that Ms. Knapp parks at night. Very clear. And again, Mr. Boykins didn't seem to believe that he had to follow those orders. When we appeared before Judge Smith on November 5th for the hearing in this matter, Judge Smith conducted what ended up being a full day hearing on this case. Mr. Boykins subpoenaed 4 witnesses to that hearing, though they weren't served properly, they weren't served correctly. My recommendation to the court was that they be allowed to testify so that we could have all of the evidence out on the table. Mr. Boykins was allowed a full hearing. He was allowed to cross-examine all of the petitioner's witnesses, and his own witness that he called Jamar Taylor testified that those were the types of things that Mr. Boykins was saying, that that Ms. Knapp and the owner of the restaurant didn't know who they were dealing with, that he would kill them, that he would blow the place up. That's all. It was all heard by Judge Smith, and ultimately, as set forth in Judge Smith's order that's in the record before you, pages 96 to 100, Judge Smith made some very clear findings. She found that Ms. Knapp's testimony was highly credible. She found that Jamar Taylor's testimony was highly credible. She found that Ms. Knapp's fear for her safety was reasonable, completely reasonable. And maybe most instructively for today, Judge Smith found that Mr. Boykins presented, quote, no evidence to the contrary. For a full day hearing, he had no evidence to the contrary. Frankly, the circuit court's determination wasn't even a close call as to whether Ms. Knapp had met her burden to the level of a preponderance of evidence. This was highly credible and reasonable testimony on one side First, absolutely no evidence from Mr. Boykins. And Judge Smith not only entered the order of protection, she extended it for an additional 2 years for a total of 3 years based upon Mr. Boykins' continued violation. And pursuant to the statute, Ms. Judge Smith determined that the attorney's fees incurred by Ms. Knapp should be charged to Mr. Boykins in the amount of $12,500. Of course, that was before. Now we're on appeal, and that number has only increased. So, Your Honors, of course, we are, Ms. Knapp is respectfully requesting that the order of Judge Smith be affirmed. Briefly, I would remind the court, as set forth in my brief, that Mr. Boykins has failed to bring forth a transcript from the hearing. He also has failed to petition the trial court to determine that obtaining that transcript is either impossible or not financially feasible under the circumstances, and he's presented this court with any sort of statement of the facts pursuant to the Appellate Rule 24. So we're here today basically with a very limited record, and it's Ms. Knapp's position that this court needs not only to follow the, look at the facts and the law of this case, but also refer to the case of Coaxley versus Daniels from the Tennessee Supreme Court, as well as the precedent of the Tennessee Court of Appeals in Fayne, F-A-Y-N-E versus Vincent. That's 301 Southwest 3rd 162, and Taylor versus Allstate 158 Southwest 3rd 929, for the proposition that in this procedural stance that we're in, that the court must presume, in the absence of a record on the proceedings, that the transcript or statement of evidence, had it been included, would have contained sufficient evidence to support the trial court's factual conclusions. The absence of a transcript or a statement of evidence significantly ties the hands of the court, and the absence of the transcript or evidence establishes a conclusive presumption that there was sufficient evidence before the trial court to support its judgment. So respectfully, even considering everything that Mr. Boykins has attempted to improperly interject into the record here, even if you considered those items, the state court precedent really makes this a hard hill for him to get over here without any real. Certainly, I would also like to briefly point out that the majority of the attachments to Mr. Boykins' brief are inappropriate. And why, I've become a target in this, I'm not sure, but he's got Facebook posts that I'm making, and that sort of matter, and mailing pleadings to my house for my family to see instead of my office. My suggestion is those types of actions need to stop. But in any event, I appreciate your consideration, and Ms. Knapp respectfully requests that the order of the circuit court be affirmed. Thank you.
Thank you, sir. All right, Mr. Boykins, you have 5 minutes to give us your rebuttal, please, sir. You need to unmute your microphone. There you go.
Your Honor, Mr. Yoakum is very dishonest, Your Honor. And the reason he said I had no evidence to support anything that I was saying or to give on the day of my hearing is because she would not accept any of my evidence I tried to offer her. I had 7 folders full of evidence, and she would not accept any of my evidence that I had to offer her. And also, Judge Smith knowingly knew that he was violating rules of civil procedure when he submitted the 51-page brief the day before the hearing and told me that I needed to answer to that 51-page hearing, which goes back to case of Photo Court Vest versus Photo Court of the United States Court. And Your Honor, and I'm not an attorney, Your Honor, so I'm doing the best I can. I'm not trying to act as an attorney, but Your Honor, the court has violated my rights, and also Mr. Yoakum. And the testimony from Jamar Taylor even proves that he was being dishonest, because he said that I told him that I would do harm to the owner and do harm to Christina Knapp and filled out the police report around again 1 p.m. when I was nowhere near Beale Street until 5:30 p.m. And I had my evidence to prove it, and Judge Smith did not want to see that evidence of my location to prove that I didn't talk to Jamar Taylor, in order for him to just say in that testimony that he just heard from me that I was going to cause harm to the defendant and also to the owner. And also, Your Honor, the courts throughout they sent it. Mr. Yoakum is also being dishonest in the brief when he says that the district attorney chose not to send the charges upstairs. That's false, because the district attorney sent the charges upstairs, and I have a copy of it also. And the grand jury decided not to go to indict me on those charges because I didn't violate the order of protection. And if I would have violated and continued to violate, as he said I did, I would have continued to get arrested, which I wasn't, because they know I didn't do any violations at all. And that'll be it, Your Honor.
Okay. All right, sir. We appreciate your argument. We appreciate both you and Mr. Yoakum being here today, participating in this Zoom oral argument. Again, yes.
One more. And another reason why I didn't have the transcripts is because Mr. Yoakum denied me of those transcripts. After I filed my appeal with the appellate court, I messaged Mr. Yoakum 5 days straight, telling him that I needed the transcripts, and he did not want to give me those transcripts at all. And after I had sent in my notice of no transcripts, we had a court date of a few weeks after it, and the judge told him that he cannot withheld those transcripts from me. But it was already too late, because I had already filed a notice of no transcripts with the courts. And I have his emails where he sent me denying me, telling me do not get in touch with anyone from his office, and also from another attorney from his office that was telling me, no, I'm not allowed the transcripts and that I can't get them and I need to not contact anyone at his office.
All right. Thank you, sir. We will attempt to get you an opinion at the earliest possible time. We, again, appreciate everything. We appreciate Mr. Hibner and his putting all this together and being the quarterback of all this, as well as the AOC staff and their technology wizards. So that will conclude this case. Mr. Hibner, if you will recess this case until the call of the next case.
This honorable court is now in recess until 2 p.m.
Thank you, gentlemen.
You're welcome.